is calling 2022 CR 6643. Everyone please whisper. State of Texas versus Karen Munoz. Can I have parties announced for the record for the state?
The state, Your Honor.
Defense?
John Young for the defense.
And are you Karen Munoz?
Yes, ma'am.
You entered a plea on January 10th of no contest, applied for probation. The court found the enhancement true
Yes,
based upon your plea of true. And then you did not show up for sentencing. And so,
Told me that she missed the date. That's all, Your Honor. And then she just got scared.
all right, according to the plea bargain agreement, punishment is to be assessed at 5 years in the prison. There is no application for deferred adjudication, and the state is recommending community supervision. Was there a TAP evaluation in this case or no?
I don't believe so, Your Honor. I think it was just set for sentencing.
Okay,
She has her own business and she wanted to get it set up so that she could, in case she decided to do something other than probation.
okay, let me see here. All right. Anything else you wish to say on behalf of your client?
No, Your Honor. We would ask you to follow the agreement.
All right, can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am, Your Honor.
All right, you can lower your hand. So why didn't you show up for court?
I came on the 4th, February the 4th, and it was closed, and they gave me a resentencing date. I thought was for the 10th on my birthday, but it was for the 7th of February. And by then I already had the warrant, and I was just like, this warrant has plagued me. I'm glad that I'm here and can get this over with. I need to get it behind me and
No,
hopefully
you were set for February 7th. There was no fourth date.
No, I came on the 4th. On February the 4th, they gave me a resentencing, and I thought it was for the 10th, the next pay.
No. What I'm saying is on January 10th, I originally set you on February 7th because that's why it's written here.
I still have the paper, the pink paper, but I came on the 4th. I was just a miscommunication, I guess, on my behalf.
All right. Are you employed?
Yes, I have my own business. It's a removal of
Okay, stop
waste.
talking so fast.
Sorry, nurse.
All right. So what do you do?
I remove industrial waste
And how long have you been doing that?
since November 11th of 2021.
Do you have any children?
They're all adults.
All right. What are their ages?
My youngest is 18, 25, 24, 21, 19, and 18.
All right. Do you have any grandchildren?
Not yet.
What do you mean not yet?
I mean, hopefully one of them will have a baby. My daughter teaches in 3rd grade. She's not.
No, I'm wondering, is anyone expecting?
No.
All right. This is a drug case. So what's your drug of choice?
I used to do drugs a long time ago. I don't do drugs anymore.
What's your drug of choice?
I don't have one.
Well, no, this is a drug case.
Yes, the drugs were found in the car, but I haven't done drugs in about 7 years.
What drugs have you done in the past?
I used to do heroin for a long time,
When's the last time you used heroin?
about in 2016 maybe.
All right. And the drug in this case is meth. Have you ever used meth?
No.
All right. So you're the only person in the vehicle in this car.
Yes.
The officer's saying that they found the drugs on the center console in plain view. So how could you not know there was meth in the vehicle?
Because it was like 2:00 in the morning. I was going to go buy a loaf of bread and it was not my car.
It says there was crystal-like substance next to E1 with a torn baggie in the cup holder. So you're telling the court you don't have any drug problems?
No, not.
All right, this is all on the record. And I'm telling you right now, if you want to insist that you haven't used drugs for a long time and that you have no drug issue, then we're not going to address that. But do not come back to this court on a motion to revoke saying you have a drug problem.
Yes,
do you
ma'am.
understand?
Yes, ma'am.
So do you want help for your drug issue or no?
No, I don't.
Okay. In probation, if you'll make a notation that she has no drug issue. All right, this is what the court is going to do. The court is going to sentence you to 5 years in the prison, suspended and probated for 5 years. There's a $2,500 fine. That will be probated. There's to be regular reporting by Zoom or in person. I'm going to want random monthly UAs, proof of employment within 30 days of release. There's to be no employment as a home health care provider or with minors. 180 hours of community service restitution. If she wishes, she can buy out of that at $7.25 per hour. And I'm going to suggest the San Antonio Food Bank, but If there is another charity you would like that donated to, you can let probation know. And if it's on the approved list, then it can be for that. I just choose the San Antonio Food Bank because usually there's a shortage of food.
Your Honor, is she allowed to continue her business as the employment?
Yes, as long as it's not as a home health care provider or with minors.
Thank you, Your Honor.
There's to be no unsupervised contact with minors. I'm going to want field visits 1 time per month for 3 months, and then probation at your discretion. Probation, is there anything else she needs?
Okay.
Right away, this case hinges on plain view. If drugs are visible inside a vehicle, prosecutors don't need proof of ownership, just knowledge and control, and that's a huge problem for the defense right from start.
All right, anything else you need from the court to be successful?
Thank you, Your Honor.
Anything else you need?
No.
All right, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. He beat you to it, Mr. Young.
Yep, he did. He's fast.
Did you review that document with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. So what's the tattoo about?
It was just my son passed away. It was only God can judge me. It was long when I got it.
Okay, I'm sorry to hear about that. And then the names?
My kids,
Okay. And then the chest?
my son.
All right, thank you. All right, the court is calling 2023 CR 0696, State of Texas versus Chris Lynn. That parties announced for the record for the state,
Anna Ochoa Nelson.
for the defense.
Cornelius Class for the defendant.
And are you Mr. Lynn?
Yes, ma'am.
All right. You entered a plea to the lesser included offense of indecency with a child by contact on December 6th.
Yes, ma'am.
My understanding, you entered a plea of no contest.
Yes, ma'am.
While it's not written on the docket sheet, the court did review what the previous judge who took the plea read. And I know that that judge found there was sufficient evidence to find you guilty, but the court deferred finding of guilt. I read the police report and the stipulations, but I'm basing my decision just on the police reports. I'm also finding that there is sufficient evidence to find you guilty. However, I'm deferring finding of guilt because you've applied for deferred adjudication. According to the plea, punishment is to be assessed at a cap of 10 years in the prison. There's a $1,500 fine, and the state is opposed to your application. There's to be Chapter 62 compliance and no contact with the complainants. Have both parties had a chance to review the PSI report, state?
Yes, Your Honor.
Defense?
Yes, Your Honor.
Any objections to the PSI report, state?
None from the state.
Defense?
No, Your Honor.
All right. Any witnesses, state you're opposed?
No witnesses from the state judge just for me.
All right. Defense, any witnesses?
No, Your Honor.
All right, then the court will hear argument. State, you're opposed?
We are opposed, Your Honor. We would ask that you hit the cap of 10 years and send the defendant to prison. He perpetrated numerous sexual assaults on the victims in this case. Alyssa is the oldest victim and the victim that the state has had contact with pretty much this whole time, Judge. I did speak with her in person and just want to let the court know that she was extremely emotional when describing the acts that her stepfather perpetrated upon her. It was very difficult for her to talk about. She had to take several breaks, and it was very emotional for her. You can see the impact that it has upon her in her everyday life.
Missing sentencing is one of the worst mistakes a defendant can make judges take it personally because it signals disrespect for the court, even if it's just a mistake. Fear doesn't excuse a failure to appear.
The youngest victim, Ariana, the state has not had the opportunity to speak with in person. The mother of Ariana has not allowed us to speak with her. However, Judge, I believe last week she did finally turn 18 years old. It was unfortunately not in time for the PSI officer to reach out to her and to get her opinion on what should happen in the case. However, in speaking with Alyssa, I want to comment on the no contact order. Alyssa does not wish to have contact with the defendant. I don't have that coming from Ariana, Judge, but again, Alyssa is very emotional about the whole thing. She doesn't want to do anything that will get anybody in any more trouble than we already have here today. So these acts with regard to Alyssa were perpetrated on her numerous times over the course of years, each time that her mother went to work and the defendant was granted access to her. And they were escalating in nature. It began with touching and escalated to full-on penetration of the complainant's sexual organ by the defendant's penis on numerous occasions. We did plead to a lesser included, Judge, but those are the facts of the case. With Ariana, we do have indecency with the child by contact, where the defendant made her touch his erect penis on more than one occasion, Your Honor. We would ask that you send the defendant to prison for the full 10 years.
All right, defense.
Excuse me. On behalf of my client, Judge, he doesn't have a significant criminal past history. My client feels that he would be a good candidate for probation if, notwithstanding what rules that court can place upon him, he feels that he would abide by those rules. He would govern himself. If there's a violation, then at that point, the court would have a full range of punishment if the court wants to send him to prison. He just feels, Judge, that if he's given that opportunity, that chance, he would take whatever courses he need to take, anything that has to educate himself with regards to the nature of these cases. He's more than willing and able to do, and we just asked Judge that the court consider deferred in this case, and that's our position, Judge.
All right. Mr. Lynn, is there anything you wish to say?
No.
Any questions for Mr. Lynn?
No, I don't have any questions.
Okay. All right. What I can tell you is I don't have a trial court certification. It was one that was done by Judge Angelini that was signed, but I need one for today. A trial court certification of defendant's rights to appeal.
You want it post sentencing or?
Well, if you all can grab it now, and then I'll make my decision. And I do have a question that maybe counsel can answer for me. In the stipulation, it says, and this is the narrative, so I'm assuming it's coming from your client. It says that he is married common law for 18 years and has a 15-year-old son.
Yes.
So
Here's the red flag: admitting prior heroin use while denying any drug issue in a current meth case creates a credibility gap. Judges listen very carefully to consistency, and contradictions don't go unnoticed.
is that person that he's common law married to the same person that's in this?
This person that he's common law married to, forgive me, Your Honor, I don't recall her name, but that is Ariana's mother.
Okay. And are they still together?
Yes, Judge.
So I'm assuming that is why, well, I don't like to make assumptions. So is that the reason, my question is that the reason why there is trouble having the other complainant come in?
I believe so, Your Honor.
And when it depends on how you define trouble, so sometimes trouble could be also a good trouble. You know,
Yes,
I've heard that phrase.
I've heard that phrase too, Mr. Cox. She was supposed to come here today, but I think that she may have had some reservations about how everything kind of came to fruition. And I believe that she has, there's still a relationship between her
in my client.
Well, if you would like her to zoom in, she's more than welcome to zoom in.
Let's see if I
And if you want her to zoom in, I'm sure she'll be subjected to questioning. How rigorous the questioning is, I guess, depends.
do we know whether the questioning will come from prosecution or the court? That's basically.
State, will you have questions?
Oh, I have a lot of questions, Judge.
They will come from the prosecution. If no one wants me to ask questions of her, of course, I will not ask questions of her because she's a witness. The only person who's remained their right to remain silent has been your client. So if you all would like her to appear by Zoom, State, will you have any objections to her appearing by Zoom?
No, Judge.
All right, we can have her appear by Zoom.
For again.
Of course. And we're off the record. Ms. Abrams, on Mr. De Hoyos, we had talked about that case.
Yes, sir.
I received an email from Felony Drug Court. They're willing to speak with him if he wants to go back to Felony Drug Court.
Yes, I'll be here in the morning.
Okay. All right. And I'll forward their response because his caseworker, former case manager is willing to meet with him. All right.
Let me see if I can call her. Jen.
Okay, sure. Just have a seat.
She's in the hospital. Her brother is on hospice, and like he's dying. She's not able to do the Zoom. And she won't be available not this week, but next week. So, I mean, not next week, but the following week. We can set it that, because that's the only thing we got to do. I mean, it's.
All right. Let me see.
This warning is critical. The judge is locking the record. If probation is violated later, the defendant can't suddenly claim addiction as mitigation. That door just closed permanently.
So, State, will you have any objections for this being set the week of January 15th for sentencing, or will you be here?
I will be here, Judge, but if something happens and I'm sick, my team can fill in, I'm sure.
All right. And if you want to appear by Zoom, will she be allowed to appear by Zoom?
That's fine.
All right. So, 15th holiday.
15th, that's Martin Luther King.
Yes, I will be there marching in a van. So, well, you can stop the van and then get out. Yeah.
Okay.
So we have the 16th, which is a Tuesday.
What about the Wednesday? You can't do the Wednesday?
No, Wednesday, that week, if we're in jury trial, which we probably will be, Wednesday is all day jury trial.
And Thursday is all day jury trial too.
Thursday, we could do it Thursday morning, but usually Thursday morning is pretty busy.
We do it to Tuesday, right after Martin Luther King Day.
All right, so we'll come back on January 16th. And could I have his trial court certification? Have you filled it out yet?
I haven't filled it out, Judge. I was contemplating. Let me.
All right.
So that there was not one.
There was one, but Judge Angelini signed it.
And what did he do with it?
Oh, it's in here, but he's signed his name and he's already checked the box and it's just the original. There is no copy.
All right, that's fine. Let me know.
All right. So we're going to be back on this case on January 16th. Mr. Cox, you'll need to be here exactly at 9 because we'll be in a jury trial.
Okay. But on that Tuesday?
Yes.
Okay.
So I'll need everybody here exactly at 9. So we'll come back on January 16th. The witness can appear by Zoom. State has no objection to that. And if need be, Ms. Ochoa can appear by Zoom. But I know she's going to be healthy and she's going to be fine.
Fingers crossed. Getting worried. They're dropping like flies up there.
Ah,
Yeah. That's now on your six.
2021 CR 9763C, State of Texas versus Thomas Blinko. Can I have parties announced for the record for the state?
Nick Wilkins for the state, Your Honor. Roger Bettis for Mr. Blanco, Your Honor.
Are you Mr. Blinko?
Yes, ma'am.
Counsel, have you received all the discovery? Did you review it with your client?
Yes, Your Honor.
court will find that the state is in compliance with discovery. Mr. Blinko, I'm showing you what's entitled application for deferred adjudication or community supervision. Did you review that with your attorney? Did you understand it?
Yes, I did, ma'am.
And did you sign it?
Yes, I did.
Going to show you what's entitled true bill of indictment. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Mr. Blinko, I'm showing you what's entitled court admonishments and defendant's waivers and affidavit of admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
I'm sorry.
Did you understand you're charged with the offense of robbery? That's a second-degree felony. The range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes, sir. I mean, yes, ma'am.
A felony conviction carries lifelong consequences, including permanent loss of firearm. Rights many defendants underestimate how much follows them long after probation ends. This is where everything changes. We move from a drug probation case to allegations involving a child, and the legal standards, emotions, and sentencing stakes skyrocket.